Hey everyone, welcome to Fiveable Stream tonight. We are going to be discussing civil liberties, and we are specifically going to be looking at First and Second Amendments when it comes to civil liberties, and this is all part of the AP US Government and Politics course. So as always, here's where you can reach us on social media. So at Think Fiveable on Twitter, on Instagram, and on YouTube. Always feel free to reach out to us, ask us questions, suggest streams. If there's a topic you think we're missing that will be important for your course, we're always happy to hear from all the students who are participating with us. So tonight, again, we're going to be looking at the First and Second Amendment and civil liberties. So we're going to start off by just defining what civil liberties are. Then we're going to break it down. We're going to talk about how our government has really struggled from the get-go. From the first moment our Constitution was created and the Bill of Rights was put into place, our government has struggled between the concept of keeping order within our country, but also at the same time guaranteeing people freedoms and liberty. And we're going to talk a little bit about that. Then we're going to get into the nitty-gritty about the First Amendment. Now, the First Amendment is very large. We're only going to be looking at a couple aspects of the First Amendment tonight. Specifically, we're going to be looking at freedom of speech, we're going to be looking at freedom of the press, and then we're also going to be looking at freedom of religion. And then once we feel like we've done enough with the First Amendment, we're going to jump into talking about the Second Amendment, which we hear about all the time lately, right? The right to bear arms. We're constantly especially in schools, I'm sure, being inundated with the question of, should there be limitations on this? And it's the same thing we're going to talk about with the First Amendment. What type of limitations should there be when it comes to speech, press, and religion? So we're going to break all that down, and we'll end the stream tonight with a bunch of practice multiple choice questions to review some of the Supreme Court cases we're going to discuss and just review where our government currently stands when it comes to issues of the First Amendment and issues of the Second Amendment. Feel free as I'm going through to answer questions. The way I usually do it, I like to kind of get through the end of the slide and see if there's any questions that have been posted. So if you do post a question and I'm not answering it right away, know I plan to get to it. It's just sometimes I get a train of thought going and I just go full speed. I don't stop. So we're going to start off with just breaking it down from the get-go, right? We got to talk about what civil liberties are. So if you look at the definition of civil liberties, it's those personal freedoms that are protected from arbitrary government interference or deprivations. That is the basic interpretation of what civil liberties are. If you look at our Bill of Rights, the Bill of Rights was specifically created and added to our Constitution to guarantee us Americans this concept of civil liberties. But we've struggled from the get-go, right? I mean, even in the beginning, think about it, they didn't want to put the Bill of Rights in at first, right? That was the first 10 amendments to our Constitution. It's not the original part of the Constitution. But our country has always struggled because it's this question of, how do we define free speech? What exactly is an unreasonable search? What does freedom of religion mean? What does the right to bear arms mean? Does it mean the right to bear any type of gun? Or are there limitations to all these different rights? And when our government first put in the Bill of Rights, one of the things that they were very concerned with was the fact that you want to guarantee people their rights and freedoms, right? Especially they just broke away from the king. They were frustrated with the king that the king had taken away a bunch of their rights. So you don't want to start off this new government by restricting them. At the same time, if you give a country and its people too many liberties, do you lose a sense of order within your country, right? And in order to function, you need some sort of order. So it's always been this balancing act, and a lot of it has actually fallen on the Supreme Court to make decisions as to what are those limitations that we might face. And again, the Bill of Rights are there specifically to protect us from the government, right? To make sure that the government isn't going to become a dictatorship, to make sure it's not going to become tyrannical and take away our rights. And that's why those Bill of Rights were put into place. We're going to see as we kind of jump into this that there are going to be a bunch of court cases we're going to talk about tonight. Specifically for the AP exam in general, We're going to talk about more court cases than need be, just to kind of fully understand the idea of these Bill of Rights. But what's important to understand, there are key cases that you will see included on your exam. So just keep these cases in mind, and I'll kind of refresh your memory when we get to them. But Schenck versus the United States, Tinker versus Des Moines, New York Times Company versus the United States, Engel versus Vitale, Wisconsin versus Yoder, and McDonald versus Chicago. That's 6 cases for sure you will see on that AP exam that we will be talking about tonight. So you can see how important civil liberties are in our government, that they're that much of a focal point of the AP exam. So again, I'll remind you of those cases when we get to them. I just want you to know that there are 6 cases tonight that we're going to talk about that will be relevant to your AP exam. I'm going to flip to the next slide, but if you have questions, don't hesitate to ask them as I'm kind of changing to the next slide. Try to get my cat down off of me here. Okay, so let's jump right into talking about the First Amendment. So the First Amendment has a lot to it. We're really going to be focusing on freedom of speech, freedom of press, and then we'll talk about freedom of religion a little bit later. You'll see that sometimes freedom of speech and freedom of the press, especially when the court has to talk about it, the court hasn't made a lot of distinction between the two. What we do know from the Supreme Court is that there has to be some sort of substantial or compelling government interest, something to really justify infringing upon your freedom of speech or your freedom of the press, okay? It can't just be the government saying you can no longer criticize the government and print things bad about the government. There has to be a compelling government interest. And that's very subjective when you think of it, right? And so that's why we do see a lot of these cases going to the Supreme Court, because in the end, they're going to be the ones who will end up determining whether or not there is some sort of compelling government interest. So again, the court has not made a lot of distinction between speech and the press. What we do see as far as the court is concerned, we do see the fact that when they're talking about speech and when they're defining what speech means, it can include a bunch of different expressions. So speech can be like your actual words, like obviously I'm speaking right now, but it doesn't necessarily have to be words. It can actually be a lack of words. Speech can be considered pictures. It can be considered actions you might take. So we've actually seen the definition of speech kind of get extended. And we'll see that our First Amendment, even though we have freedom of speech, it doesn't protect all speech, okay? And we're going to look specifically at speech that might invite some sort of danger, speech that might be seen as obscene, or speech that might violate an existing law. We're going to see the First Amendment won't protect you in those situations. We also know that the government doesn't really have what's known as a prerogative of prior restraint. So prior restraint means the right to stop spoken or printed expression in advance. And that's going to come into importance when we talk about New York versus Minnesota and when we talk about the New York Times versus the United States. That's going to make a little bit more sense as to what prior restraint means. And we're going to get into those court cases a little bit more specifically in a little bit. We're not going to jump into them right now. We're going to just flip here, and we're going to now start talking about some specific court cases. So Schenck versus United States, the first court case we're going to talk about. This, again, is one of those super important court cases to your AP exam. So as I'm discussing it, feel free. If something gets confusing, you might have a question, whatever it might be, please ask. So this is where the famous quote, "a clear and present danger," comes from. I'm probably going to date myself, but there's a Harrison Ford movie called Clear and Present Danger. That quote comes from the Supreme Court opinion of this case. Basically, in this court case, the Supreme Court is looking at free speech, right? And they're basically determining the fact that there are going to be limitations on free speech. And specifically, they're going to say there's going to be limitations on free speech during wartime. So this court case is going to take place during World War I. It's basically what we see at this time. In 1917, there's some sedition and espionage acts that are passed in our country that basically prevent you from being allowed to criticize the government, prevent you from saying you want to lead a rebellion in our country, or basically incite any sort of disloyal behavior in our military. And so what we have here is a gentleman, Schenck, who basically starts trying to hand out pamphlets talking bad about the draft that our country had, right? And talking about the fact that the draft is basically like slavery. It goes against our 13th Amendment. It goes against the 13th Amendment, which put an end to slavery. And so he starts handing out all these pamphlets during World War I, saying the draft is a bad thing. So he gets arrested for doing that. And he's found guilty in court, and he basically says, hey, wait a second, you can't put me in jail for this. It's my First Amendment right to be able to print these pamphlets and speak out about it. And so basically the court has to decide, does the government's prosecution and punishment for expressing opposition to the military draft during wartime, does that violate the First Amendment's first free speech clause? And basically what the Supreme Court says is that no, at times, especially in war times, you can lose your freedom of speech. And they basically set what becomes known as a clear and present danger test. And the whole idea is the fact that if your action, whatever it might be, so in this case, if it's handing out pamphlets, if it's speaking, whatever it might do, but if it's going to create some sort of clear and present danger for our country, at that point in time, you are going to lose your freedom of speech. So a perfect example of this, just to make it a little bit more relevant to you all, if you are in a movie theater, right, you can't yell fire if there is no fire. You could actually get arrested for doing that, because yelling fire when there is no fire could create a dangerous situation. It could create a clear and present dangerous situation in the fact that people might get injured trying to escape from a movie theater in which there is no fire. So that all goes back to Schenck versus the United States. And it's this whole concept of a clear and present danger. If what you are doing, whether it's handing out pamphlets, speaking, whatever it might be, you could lose your First Amendment rights, especially if it's happening during the time of a wartime. So that's just important to understand, because again, that's a super important court case that you are for sure 100% going to see on your AP exam. Other court cases that are similar to this, there's two other court cases. These court cases you won't necessarily see on your AP exam as far as Abrams is concerned. It's just important if you're ever having an essay that you're writing about Schenck, you could always back it up by talking about the Abrams case, or even this other case as well, Bridenberg versus Ohio. So not necessarily cases that you need to know for the AP exam. They're not one of the top 6 that I talked about. But the same thing, Abrams versus United States, also taking place during World War I. And this is a case where the United States are basically participating in a military operation on Russian soil. They're participating in this operation against Germany. And basically what we see is a lot of Russian immigrants in the United States start handing out pamphlets calling for a strike to undermine the U.S. war effort. And so they were arrested for handing out these pamphlets. And basically, once again, we have here the court ruling that calling for a general strike is a violation of the Espionage Act. Hold on one second, I need to get rid of this cat who's driving me insane. Is a violation of the Espionage Act. And again, because this is during a time period of war, you are going to lose your First Amendment right. Is Texas versus Johnson a similar one for freedom of speech? Awesome question, Dakota. So Texas versus Johnson, in that case, what we see happening is that's talking about flag burning, right? So we have in that situation Johnson, who burns an American flag outside the Republican National Convention in Texas. He does it in 1984. So that's more considered a case of symbolic speech. And also with that court case, it's not taking place during the time of like a war per se, right? The other cases we're talking about come about during World War I. So in this case, the majority of the court basically says that burning an American flag is a form of symbolic speech, and that's protected by the First Amendment, which means they're actually saying you are allowed to burn the American flag. So it's a little bit different just because that has to do with symbolic speech, and that's just kind of a little bit different than this whole idea of a clear and present danger, and the fact that you might be inciting in some sense some sort of violence or inciting something that might hurt our government. So in Schenck versus United States, telling people not to get involved in the draft could hurt our government, right? Because then we're not going to have people to fight on our side. In Abrams versus the United States, telling people to strike, and they were telling them to strike at a factory that was making a lot of the wartime goods, that's going to hurt our country. So yes, it's about freedom of speech, just a little bit different as far as the type of freedom of speech, but awesome question. As far as the Cold War is concerned, so the Cold War is that war that really is taking place between the United States and the Soviet Union that picks up at the end of World War II. And then it's going to really continue on until the end of the late 80s. It's not a war in the sense that we never declared war, but we do see some different laws and then speeches being passed during that time. So we do see the Smith Act get passed in 1940 that basically made advocating the overthrow of any government in the U.S. a criminal act. And because of that, we're also going to see, once again, court cases come up. Specifically, so that Smith Act is being passed in 1940. Vietnam is going to be taking place years later. But during Vietnam, what we're going to see is that we're going to have lots of people protesting the Vietnam War. Specifically in the United States versus O'Brien, David O'Brien is going to burn his draft card. And he does it in front of a Boston courthouse. And he was basically convicted for burning that draft card. Because the Selective Service law said you're not allowed to burn your draft cards. So he appeals to the Supreme Court saying that it was a symbolic act of speech. So this court case, Dakota, is going to actually match up better with your Texas versus Johnson case. So he says the burning of his draft card is a symbolic speech. The court basically says, no, that's not considered a symbolic speech. Again, because in this sense, they're saying that they're going to side with government's right to prevent this behavior because it's protecting Congress's authority to raise and support an army. And so O'Brien disrupting the draft effort by burning his card and publicly encouraging others to do the same is very similar to what we saw taking place, right, in Schenck, in a sense, where they were trying to get people, where he was handing out pamphlets telling them not to take part in the speech. So symbolic speech is a situation there. In this case, though, with this symbolic speech, they're saying, no, you're not allowed to burn your draft card. But in Texas versus Johnson, that's going to be a situation where we are going to see them saying, yes, you can burn the American flag. And we're going to get, as you can see, a little bit more into Texas versus Johnson in a second. Before I talk more, that was a nice interlude, though, into symbolic speech, so I appreciate that. Before I get into more symbolic speech, though, any questions? All right, cool. So let's jump right into then talking about symbolic speech. So symbolic speech, basically, if you want to define it, it's basically when you're defending an act that might otherwise be illegal. So you're doing something in order to defend something that might be illegal. So it's not, whenever you try to say, oh, I did this because of symbolic speech, there are guidelines for that. So you just got to be careful about that, right? And we see things such as burning draft cards and stuff like that don't count as symbolic speech. So Cohen versus California, what we're going to see with that court case is similar to the O'Brien thing. So in the O'Brien case, we say you can't burn a draft card. But in the Cohen case, which is similar, the a similar situation, we're going to see that the court says that they can't prosecute Cohen for his expression. And in this case, what Cohen did was he wore a jacket that said F the draft. So he's not burning a draft card like we saw in the other case. And so in this situation in Cohen versus California, they're saying him wearing a jacket saying F the draft is actually acceptable and okay, as far as symbolic speech is concerned. Flag burning, again, Texas versus Johnson, which you brought up earlier, which was great timing in the way in which you brought it up. So in Texas versus Johnson, we do see that situation where they do rule that flag burning is allowable. And we're going to see that take place in that court case. And the United States versus Eichmann, it's going to be the same situation. The fact that in that case, we see once again desecrating or burning the U.S. flag being brought up, and again them saying that that's completely okay, because that is, for instance, symbolic speech. By burning the flag, you're not advocating against a government action such as entering the draft. You're hurting the reverence of the flag, but they don't see that as, again, presenting any sort of clear and present danger along that line. Was the United States versus O'Brien case the first time the symbolic speech issue came around? That's a really good question. I honestly don't know offhand if that was. That's a super good question. If we have time at the end of this stream, that's something I can investigate a little bit further. But offhand, I'm unfortunately unable to answer that question. You've stumped me there. As far as symbolic speech is concerned, though, like I said, they do look at a couple things to determine whether or not things can count as symbolic speech and where, again, your First Amendment limitations are. So basically, the court is looking at whether the regulation suppresses the content of the message or simply regulates the accompanying conduct. So they're looking at is the government, through whatever law they're passing, are they suppressing what's being said? Or are they suppressing the time, place, or manner in which it was expressed? So again, if we look at the Cohen and O'Brien rulings, right, in both cases, someone is expressing opposition to the Vietnam-era draft. They're both taking place during that time. O'Brien burning a government-issued draft card. The court says that's not protected free speech. But on the other hand, Cohen publicly expressing dislike for the draft with an, kind of hated phrase printed on his jacket, didn't do anything to incite public protest. So burning the card incites public protest, not just wearing a shirt that says something, not really inciting it. So time, place, and manner regulations have to be tested in order to come up with whether or not this is something that's going to fall under symbolic speech or not. Again, a super important case for your test for the AP exam is going to be Tinker versus Des Moines. And what this case said is, or the question this case was answering was, does a public school ban on students wearing armbands in symbolic political protests violate a student's First Amendment freedom of speech? So basically what we had during this case, again, taking place during the Vietnam era, we had a bunch of students who decided to wear black armbands for a period of time. And they were also fasting, but this is more about the armbands that they're wearing. So they wear them to school. It's their way of protesting the Vietnam War. The school administrators, so the principals, learn about this protest. They feel as though the black armbands are going to become a distraction for the other students. And so they told these students basically that they weren't allowed to wear their armbands because they were afraid that they were going to be a distraction. So the students, getting the support of their parents, which is always important, they refuse to remove the armbands. So then the school suspends the students until they're willing to come back with taking those armbands off. So this is going to end up in the Supreme Court. And basically, the Supreme Court says that if you look at what took place in the school setting, there were no facts or anything to show that disruption did take place. So the court ruled in favor of the students, saying that the students had the First Amendment right to political symbolic speech based on the First Amendment. And so they overrode the administrators who basically said you have to take the armbands off. So in this sense, we see once again symbolic speech being protected, and it's all because if the school cannot prove that those armbands created some sort of disruption. So that, again, is one of those cases that you will for sure see when it comes time for the exam. Before we move into obscenity and what exactly that means and how the Supreme Court has ruled on it, are there any questions? All right, then. So moving into obscenity. So obscene speech, the First Amendment doesn't protect it. There's no national standard that defines what it is. And so that makes this one a little bit harder and a little bit tricky when it gets to the Supreme Court because it's so difficult to define. We've had a bunch of cases as far as obscene speech is concerned that are important. We've also had a bunch of laws that are important as well. So let's first off start with Comstock. So basically what happens in this situation, in the 19th century, some states outlawed obscenity, right? So in the 1800s, we see a lot of obscenity being outlawed. And basically the reason a lot of states were doing this was because a lot of places were publishing birth control literature. And so Anthony Comstock, he's the postal inspector. Basically, he pushes for laws to ban this type of obscene behavior. They saw birth control literature as being obscene. So in 1873, we're going to see that Comstock law come into place, which basically bans the publishment of what is seen as obscene speech. So that's going to bring us to the case. And now that law is passed in 1873. I just want to make note of that. That's going to bring us to the case of Roth versus the United States, which is going to take place in 1957. So we're talking about almost 100 years after this law is put into place. Samuel Roth, he's a longtime publisher of questionable books, and he's basically prosecuted under the Comstock Act. He had published and sent through the mail a magazine that was called Good Times Magazine, and it contained partially airbrushed nude photographs. On the same day that the court is hearing the Roth case, which is going to be interesting, they're also looking at another case that's examining a California obscenity law. So basically, in this Roth case, the court defines speech as obscene and unprotected when the average person applying contemporary community standards finds that it appeals to be the prurient interest, meaning that it's having lustful or lewd thoughts or wishes. So basically, there's a lot of ambiguity in the decision that they come up with. Roth does end up in jail because basically the court, by saying this, they're upholding those obscenity laws as being constitutional because what they saw with this Good Times magazine is that there was no redeeming social importance to the magazine. But again, the way in which they describe it, right, when the average person applying contemporary community standards, that makes it super difficult to define what exactly obscenity is, how they will know it in the future. And so that's why we're going to see more court cases come about pertaining to this. Miller versus California is going to take place in 1973, and we're going to see what becomes known as the Miller test after this. So in Miller versus California, Marvin Miller basically does this mass mailing promoting adult materials. A number of recipients, a number of people who receive these things in the mail complain to the police. And so California authorities are going to prosecute Miller under the state's obscenity laws. And basically, when it gets all the way to the Supreme Court, sorry, my cat just scratched me. When it gets all the way to the Supreme Court, the justices are going to reaffirm that obscene material is not constitutionally protected, but they modify the Roth decision. So they're still saying you can't send obscene material through the mail. It's not protected. That's not your freedom of press to do that or your freedom of speech to do it. But we're just going to modify that Roth decision. And so what they're going to do here is they're going to say obscenity is not necessarily the same as pornography. Pornography may or not be obscene. So they come up with this thing that's known as the Miller test. And the Miller test, there's three components to it. The average person applying contemporary community standards finds it appeals to the prurient interest, right? So that's going back to the Roth case. It depicts or describes in a patently offensive way sexual conduct specifically denied by state law. So that's the second part. Or 3, it lacks serious literary, artistic, political, or scientific value. So still, we're seeing a little vagueness to what exactly is going to be defined as obscenity, but that Miller test at least has 3 questions that any Supreme Court will be able to look at in the future if they have cases come before them to kind of answer whether or not those materials are considered obscene or not. And we're going to move into free press in a second, but I'm gladly take any questions. All right, so then moving into freedom of the press. Freedom of the press, again, as I mentioned before, a lot of times the Supreme Court doesn't necessarily make a big distinction between freedom of the press or freedom of speech. But what we do know as far as freedom of the press is concerned is this whole idea of libel, right? And this is something that a lot of people use and throw around. So libel is a false statement in print that defames someone, hurting their reputation. So basically, you can print something negative about someone if it's the truth. If you are printing something negative about someone that's hurting their reputation and it is a lie, or you can't support it in some way, that's considered libel. And again, that's where you're going to lose your freedom of the press. And we're going to have a couple court cases that pertain to this and that are important. So the first court case that's important to understand is going to be New York versus Sullivan. And New York versus Sullivan, what we see in this court case is that in 1960, a civil rights group, including Martin Luther King Jr., puts an ad in the New York Times entitled "Heed Their Riding Voices." And this ad is going to include some inaccuracies and some false information about a Montgomery, Alabama city commissioner. And the city commissioner's name is Sullivan. So Sullivan is going to sue for libel in an Alabama court, basically saying, this ad was printed and it has false information about me. So the Times is going to appeal that decision because the initial court agrees with Sullivan. They award him all this money. The Times is going to appeal it, and the Times basically says, listen, First Amendment protects us. This was a small mistake, right? And it wasn't intentional defamation, meaning we didn't intentionally print this ad to lie. This was an honest mistake that was made. We want to apologize, whatever. So the Supreme Court is actually going to side with the newspaper. And basically, the Supreme Court is saying the standard to prove libel is very high. The suing party, so in this case Sullivan, he would have had to have proven that he was damaged and that the offending party knowingly printed the falsehood and did so maliciously with intent to defame. So what's interesting in this situation is it's really saying with libel that, yes, someone might print something false about you, but one, you need to prove, according to New York Times versus Sullivan, that it actually hurt your reputation. And 2, you have to prove that that's what their intent was to do, that they were purposely, knowingly lying about you to maliciously hurt you. So that New York Times versus Sullivan case is going to really create a standard that in the long run will determine what exactly libel is. It's also going to make it super difficult for public figures. Public officials are really less protected than lay people. It's easier for us who are kind of just Joe Schmoes to go and win a libel case than it is for someone who is a public official. And we're going to see, again, other similar court cases like this. A big one, and one that you should know for that AP exam coming up, is going to be New York Times versus the United States. And basically, in New York Times versus the United States, here again, we're looking at the printing of something that the New York Times did and whether or not they had the right to do it. So in this case, this is taking place in 1971. Daniel Ellsberg, he's a high-level Pentagon analyst. Basically, he's upset with the war in Vietnam, And so he releases a massive report to the New York Times that becomes known as the Pentagon Papers. And basically, in this massive report, it's top secret information, right? So it's classified information. And it basically talks about America's entry into the Vietnam War. And it reveals a lot of the government deception that took place surrounding the Vietnam War. So ways in which our government had kind of lied to us about what was exactly going on in Vietnam. So when these papers, these Pentagon Papers, are put into the newspaper, our government's credibility, President Nixon's credibility is all hurt, right? Because nobody trusts the government and nobody trusts Nixon anymore. And so what ends up happening is the United States basically sues the Times and says, listen, you need to stop, because they were printing these papers in installments. They didn't print them all at the same time because we're talking about thousands of pages of papers. And they basically say, listen, you need to stop because this is a matter of national security, right? You're actually hurting the security of our country by doing this. So it goes all the way to the Supreme Court, and the Supreme Court is actually going to rule in the New York Times' favor. And basically what it says is that you can't just go and cry national security to justify censorship, okay? So basically the court is saying, in this case, the fact that, they felt as though the government was quickly crying national security, and that wasn't actually the issue. And so that the Times was allowed to print this material. And it basically is important later on because it's going to really change that relationship between our government and then the media and the way in which they interact with one another. And so this is a huge case, and it's kind of fascinating when you think about today and we think about the impeachment hearing and everything that's going on, and the way how our government is trying to stop people from testifying because of national security. And so it'll be interesting if it goes to the Supreme Court, if that argument's actually going to end up holding up. So that's kind of done as far as freedom of speech, freedom of the press. The next big thing and the last part, as far as the First Amendment is concerned, is going to be freedom of religion. And so freedom of religion, has been a conversation way back to when our founding fathers were first creating our government. It was this whole idea of how we wanted to have a separation of church and state. And we see two big clauses that come out during this time period. One is going to be the Establishment Clause. So members of our very first Congress, they create what's known as the Establishment Clause to prevent the federal government from establishing a national religion, again, because we want a separation of church and state. And so we've seen this as far as like local towns and local communities, right? They can't just around the holidays, like just celebrate one religion. They have to make sure they're celebrating the multiple religions that are taking place in that same holiday time period. Also, the Free Exercise Clause prevents governments from stopping religious practices. So that's really important too, meaning that the government can't pass a law saying, listen, Catholics, like you're no longer allowed to worship your Catholic faith. And that's huge when we think about like the Mormons. That's come into question a lot as far as the Mormon faith is concerned, and the government when they try to create laws against polygamy and different things like that. As far as court cases are concerned, Everson versus Board of Education, this is a case I'm just going to mention. It's not one that you'll necessarily see on the AP exam. But basically in the 1940s, my home state where I still am of New Jersey, they allowed public school boards to reimburse parents for transporting their children to school, even if the children attended a Catholic school, which was known as parochial school. So some argued that this constituted an establishment of religion by doing that. So we're going to see in Everson versus Board of Education in 1947, the court upheld the law. So the basically what they said was that the state law is not meant to favor or handicap any religion. This law gives no money to these religious schools, but just instead provides funds evenly to parents who transport their children to the state's accredited schools. So like for me growing up in New Jersey, I went to a Catholic school for elementary school and for high school. And so there was a school bus that the town was paying for that was transporting me to my Catholic school, even though I wasn't using the public school system. And basically, this law says that's allowable because of the fact that they're not just establishing one religion. Like, I went to a Catholic school, but those school buses still would have taken students to Jewish schools or Muslim schools or whatever other religious schools might have been in the community. Had the busing service only been used for one specific type of religious school, that's where the issue would have come in. So again, not something you necessarily need to know for the exam, just wanted to put it out there. Is the Scopes trial freedom of religion court case? Yeah, so the Scopes trial for sure calls into question not somewhat freedom of religion. I mean, it actually falls within the First Amendment rights, and there's a couple different issues at hand there. As far as freedom of religion and also freedom of speech and a teacher's rights within a classroom. And just like we kind of talked about when we were talking about Tinker versus Des Moines, and we were talking about whether or not students kind of lose their freedom of speech to an extent in a school, which in that case they said no, they don't, as long as it's not causing a disruption. It's kind of the same thing too with teachers as far as what's the extent to a teacher's freedom of speech. Engel versus Vitale. So that's going to be a super important. This is another one of those really important court cases you're going to need to know for the AP government exam. So in Engel versus Vitale, this court case is taking place in 1962. And basically the question that the court has to look at is, does allowing a state-created non-denominational prayer to be cited voluntarily in public schools violate the First Amendment's Establishment Clause? So basically what was taking place in a public school, parents were upset because the local school board had basically made official prayer that was going to be said before school started. And people argued that the prayer violates the Establishment Clause because it's basically choosing a religion. And so in this case, the Supreme Court is going to say yes. You cannot force students, in a sense, to pray if they don't want to. You cannot establish a prayer because of the fact that it might be used, to support one religion. And specifically in a school setting, because school attendance is mandatory, you definitely cannot do prayer before school. And it's really that mandatory component of school that made it such an issue in the eyes of the Supreme Court during that Engel versus Vitale case. And then the lemon test. So for me, whenever I think of a lemon test, I think of like, something that doesn't work. Like if you buy a new car and then it fails right away, that's a lemon in my mind as far as machinery is concerned. But in this situation, this is a court case in 1971. And basically this is Lemon versus Kurtzman. And what we have in this situation is Rhode Island and Pennsylvania are passing laws to pay teachers of secular subjects, meaning non-religious subjects, but they're paying these teachers who are working in religious schools with state funds. So it's teachers who might be teaching history, math, science, but they're teaching in a religious school and they're getting paid with state funds. And the reason being, the state says that all students, whether you're in a religious school or a public school, you have to learn English and math. And so therefore, we feel as though we should be paying the teachers in these religious schools who are teaching things like English and math because they're carrying out the requirement of the state. And so the Supreme Court looked at this and basically said, listen, there needs to be a wall of separation, right? You're kind of blurring the lines by doing this. And so what they do is they create what's known as the lemon test. So they said, this law you created is creating an excessive entanglement. In order to avoid an excessive entanglement, a policy must, 1, have a secular purpose that neither endorses nor disapproves of religion. 2, have an effect that neither advances nor prohibits religion. And then 3, avoid creating a relationship between religion and government that entangles either in the internal affairs of the other. So in this case, they said that law absolutely bogus, cannot take place. And they create this lemon test for future laws that the government might make that has to do with interactions between religious schools and the government. Other court cases, I threw a lot in here. I didn't realize how much I threw in when I was making these slides. So Wisconsin versus Yoder, though, as much as I just say I threw a lot in there, Wisconsin versus Yoder, this is another court case you will see on the AP exam. In this court case, this is 1972. The question before the court is, does a state's compulsory school law for children age 16 and younger violate the First Amendment's free exercise clause for parents whose religious practices and customs dictate they keep their children out of school after a certain age? So compulsory school law basically means that legally you are supposed to send your children to school until the age of 16 at this point in time, right? And so some religions say that their kids shouldn't be going to school at that age. And so it's whether or not we're violating some freedom of religion here by saying, no, even if your religion tells you to stop sending your kids to school, you still need to send them. And so this was going to take place in Wisconsin, where they had one of these state laws that required parents to send their kids who are age 16 and under to a formal school. And we're going to have a couple of parents who had teenagers that they did not send to school. And so they get charged for not sending their teenager to school. So the parents take the case to the Supreme Court. And basically, the Supreme Court found, and these are Amish families, by the way, the Supreme Court found that making Amish attend schools would expose them to attitudes and values that ran counter to their beliefs. So basically, they said in this situation, because of the fact that their religious beliefs were against going to school at that point in time, that they did not have to follow the law. So the court is declaring in that case that the free exercise clause overrides that state's law to promote health and safety, which is why Wisconsin said they had that law that kids had to go until the age of 16 to school. So again, that's another situation. I'm going to breeze through these real quick because this is not necessarily things you need to know for the AP exam. But there are some school districts now that have a voucher program. Betsy DuBois, who is the Secretary of Education, she's a big proponent of vouchers. And basically what a voucher program says is, say your public school spends $8,000 per student to educate their students, that a parent living in that town, if they don't want to send their kid to that public school, that they're entitled to that $8,000 to use at a school of their choice, even if it might be a religious school. And so there's a lot of questions about whether or not that's legit or legal or not, and that's something that's going to impact our country more so in the future. Also, religious symbols in town centers. This is a big thing too. The fact that, if you put religious symbols, especially around the holiday times, are you establishing a religion? So what we see a lot of towns now, like I know growing up in my town, they always had a manger out, and that was like our town government that would put a manger out. But obviously that's kind of establishing the Christian faith at Christmas time. So now what the town does is they try to accommodate for every religion that wants to put it out. So they didn't take the manger away. They're just accommodating for all the other religions that are prevalent in the community. And then the 10 Commandments, this was a big one where we saw state capitals who would have the 10 Commandments posted within their capital. And again, this is calling into question that whole idea of separation of church and state. Second Amendment, that's why I breezed through that, just to get to the Second Amendment. We may not have time for our practice questions tonight. We'll see how we do. But they're obviously always going to be there. If you go to the slide aspect, they'll always be there for you. So Second Amendment, the right to bear arms, right? That's been coming into question a lot lately with gun shootings and mass shootings and all these different things taking place. So the National Firearms Act required the registration of certain weapons, and this is in the 1930s, right? So it requires the registration of certain weapons, and it imposes a tax on the sale and manufacture of certain guns, and it restricts the sale and ownership of high-risk weapons such as sawed-off shotguns and automatic machine guns. This was done in the 1930s. You had a lot of gangsters and bootleggers, and it didn't actually get challenged that often in the beginning. But then it did end up getting challenged, and the Supreme Court ends up, for the first time, upholding the law because they said that the Second Amendment did not protect ownership of sawed-off shotguns because such weapons were never common in a well-regulated militia. Now, again, we're talking about like the 1940s and 1950s when this is taking place. We're going to see, though, that this whole gun argument and debate is going to continue as we move into the 1960s. So if you look at 1968, at this point in time, we're going to have the Gun Control Act of 1968 that's going to take place. And this has to do with the fact that in the 1960s, we have a lot of assassinations, right? We have JFK, Martin Luther King Jr., we have Robert Kennedy. So we have a lot of assassinations taking place. There's a lot of crime that's going on, a lot of illegal drug use. And so the feeling is if we pass this Gun Control Act in 1968, that might prevent some of this violence that's taking place. Later on in 1993, we're going to see the Brady handgun violence take place. And this is going to take place because James Brady, he's the press secretary for Ronald Reagan. He is with Ronald Reagan when the assassination attempt the assassination attempt on Reagan happens. James Brady ends up getting shot, and he suffers a paralyzing head wound and is in a wheelchair for the rest of his life. So they passed the Brady Handgun Violence Prevention Act in 1993 in his name, and this basically establishes a 5-day waiting period for purchase of handguns to allow for a background check and then for a potential cooling off period for any buyer motivated by immediate impulse, anger, or revenge. The law ended up expiring in 1998, but in 1998, when the law did expire, there was a similar law that was in a sense passed, which is the National Instant Criminal Background Check System. And with this background check system, basically does the same thing as far as making it so you're supposed to have this waiting day, so many days of waiting before you can actually purchase a gun. So you're not doing something in the heat of anger or revenge. The unfortunate part, though, and this is something you hear about on the news all the time, is the fact that there are a lot of loopholes. And a lot of these loopholes take place at gun shows or when it's a private seller selling their guns. And so because of those loopholes, not everyone is falling into this waiting period that's supposed to be legally in place. And so that's why a lot of times you'll hear Congress talking about whether or not these waiting periods or these gun shows, if there should be more regulations on them. So 2 important cases just to know about. So in McDonald versus Chicago, the question was, does the Second Amendment apply to the states by way of the 14th Amendment and thus prevent states or their political subdivisions from banning citizen ownership of handguns? So this is in 2010. Basically, what's happening in this court case is the fact that citizens in Chicago are challenging some of the policies and challenging some of the laws that the city was putting into place. Chicago was requiring that all gun owners had to register their guns, but then they also at the same time were refusing to allow citizens to register their handguns, creating basically an effective ban. So it's saying in order to have a gun in Chicago, you have to register your gun. At the same time, we're actually not going to let you register your gun. And since you can't register your gun, that means you can't have a gun. So this actually was a super close vote in 2002. And basically what the Supreme Court said was, yes, the Second Amendment does apply to the states, meaning that the states cannot make laws in this sense that would prevent somebody in a shady way, in a sense, from being able to own a gun. So in that case, they're saying that you cannot do that. You cannot make laws like that. And we see that around the country since then, that gun policy laws and the way that states do it have been called into question as far as what is really allowed as far as a state. So there's different state laws, and then there's obviously our national government laws. And we're constantly seeing these Second Amendment conversations take place in Congress after every single mass shooting as far as what is allowed and what isn't allowed. So that's it as far as these questions are concerned, these cases are concerned. These are, oh, darn it, these cats. These are some of the multiple choice questions I have put together for all of you. So I don't know if we want to just try to jump through a couple of them and see what we can get. But which of the following most clearly states the outcome of Tinker versus Des Moines? So remember Tinker versus Des Moines being that First Amendment case. with the students. I don't want to say anything more, but and give away the answer. But would it be A, B, C, or D? So the answer for this question, thanks Dakota for answering. First of all, I appreciate that. So in this case, the answer is actually going to be B. So in the Tinker case, the court found for the students, right? So they found in favor of the students, and they argued that students retain free speech protections while in public school, but they did suggest that public schools, in a sense, can limit student speech, and that's why it's B. And they said in this situation, the wearing of armbands wasn't a distraction. Therefore, we are going to side with the students, right? They're guaranteed their freedom of speech. But if there was a situation where it was whatever the student was doing, whatever action, whatever speech they were taking, was creating some sort of disturbance, at that point in time, the school would be able to regulate their freedom of speech. And so that's why in this situation, B would be the correct answer. Which of the following best describes the Supreme Court's interpretation of the extent to which free speech is protected under the First Amendment? And don't fall for the A is highlighted. I'm not sure why it's highlighted like that, but I'll tell you the answer is not A. So which of the following best describes the Supreme Court's interpretation of the extent to which free speech is protected? C, awesome, right? Yeah, it goes back to that whole idea of time, place, and manner. So it's the circumstances in which that speech is taking place and occurring. Okay, which of the following best summarizes the debate reflected in New York Times Company versus U.S. 1971? Hey, awesome. Good job. Yeah, so this was the situation with the Pentagon Papers, and it's can they just quickly cite executive authority or national security to prohibit papers, in the sense classified documents, from being printed? Oh, got a bunch more. Wow, I was on fire. Which of the following best describes the basis for the court's ruling that the Second Amendment confers an individual right to bear arms? So this one's a little bit more difficult. The answer for this one is actually going to be A. The court states that after recounting history related to the right to bear arms, that there is no doubt on the basis of both text and history that the Second Amendment conferred an individual right to keep and bear arms. Because of the fact that there is another government stream taking place like right now, starting at 8 o'clock, I'm not going to continue going. There were a couple more questions, and these slides are available if you go to the Fiveable website, where you'll see these questions, so you can practice on a couple of the other court cases we went over. These are our programs coming up for the rest of this week. So right now you can tune into monetary policy in the Federal Reserve. Thank you so much, and thank you for all your participation. You did an awesome job as far as knowing your court cases too, and bringing up some really relevant court cases, and that was a huge help. Next week, I'm back with critical elections on Monday, which is unusual from our usual Tuesday, Thursday, but it's a rare exception. So join me on Monday at 7 o'clock, and we'll jump into the 5 critical elections that realign political parties forever. Thanks so much for joining. Check out the one taking place right now, Monetary Policy in the Federal Reserve, and have an awesome night.